I call the honourable member Kevin Haig.
Thank you very much, Mr Speaker. It's a pleasure to take a call on this bill, one that certainly the Green Party will be supporting. It's interesting, that we've arrived today at a day when there seems to be a consensus across the House about the damage caused by driving a motor vehicle over 50 milligrams of blood alcohol concentration. And other members have already talked about some of the parameters of the problem. 30% of crashes, alcohol-related, higher proportion of serious crashes. The Law Commission, in its report, noted that drink driving fatalities in this country were higher than in other countries. 2009, 138 deaths arising from crashes where alcohol was a factor. New Zealand, as other speakers have noted, has one of the highest blood alcohol concentration limits in the world. And that the current limit's been in place since 1978. Others have mentioned the incredulity of those who test the amount of alcohol that's required to reach that 80 milligram limit. It's between 6 and 9 beers for an average adult man, or between 4 and 6 for the average adult woman over the course of 2 hours in order to reach that 80 milligram limit. And I don't know about you, Mr Speaker, but certainly speaking for myself, if I had been drinking anything like that amount, I would not be safe to drive. So what about the reform attempts in recent years? And other speakers have referred to these. We had the reduction of the limit recommended by the Law Commission. We had then the Ministry of Transport in its Safer Journeys document recommending a reduction from 80 milligrams to 50 milligrams. Interestingly, the previous speaker, David Bennett, spoke about the necessity of reducing the blood alcohol concentration limit for drivers under the age of 20 to 0 as a step towards this goal. While I commend that particular measure, I see no reason at all why this measure being introduced today could not have been introduced at the same time, as indeed had been recommended by both the Law Commission and the Ministry of Transport. There's nothing at all about reducing the blood alcohol concentration limit for drivers under 20 that was necessary to set the stage for this change that we're now proposing and considering. And interestingly, this is another one of those cases where Parliament is lagging well behind public support and public opinion. When expressed as the number of drinks needed to get to the limit, just 2% of the public actually support the current blood alcohol concentration limit. Just 2%, sir. There is extremely wide-based and strong support for making the change. Other speakers have already talked about the opportunities that have been squandered, actually, since 2009 to make this change. At the time that we made the changes to the youth limit, we could have done this. In the alcohol reform bill that the House considered last time, we could have done this, and the government chose not to. And Mr Speaker, it's my belief that the government is moving now to make this change only because Ian Leese-Galloway's member's bill was pulled out of the ballot, and therefore the government could no longer avoid the issue being debated on the floor of the House. That's why we're seeing a government bill on the matter. When we look at this bill, most of the framing of the drink driving issue has been around the proposal to lower the limit, effectively extending the category of offending downwards from 80 milligrams to 50 milligrams. And there hasn't been much discussion in the public arena, or indeed in specialist circles, around the other aspect that the government intends to do, which is effectively to introduce a new category of offending with much lower levels of penalty than the existing penalties in the current law. And I think that's an interesting point, Mr. Speaker, because the argument for lower penalties for less severe offending, of course, holds true. But even when we consider the current law, above 80 milligrams, there aren't graduated penalties above that. There are penalties, and it becomes a matter for the discretion of the judge, for the courts, to determine what level of penalty is applied. So it's a very curious approach that the government has taken to effectively introduce an entirely new and much less serious category. The point of law, Mr. Speaker, the point of law is to achieve a variety of things. One is to directly protect people from risk of harm as a result of having dangerous drivers on the roads. A second point is to actually impact on the whole range of drink driving behaviour and reduce the amount of alcohol that the whole range of people consume in relation to driving, bringing benefits right across that spectrum. And then the third benefit, Mr. Speaker, is to provide a very direct disincentive to those who might otherwise drink excessively and then drive motor vehicles. And the question, Mr. Speaker, is this: will the lower penalties that the government intends for people who are consuming to a level that takes their blood alcohol concentration to between 50 milligrams and 80 milligrams, will those lower penalties be sufficient to achieve the disincentive effects that we want and those other benefits of the law change? And I'm going to be very interested to hear what submitters say to the Select Committee, Mr. Speaker, because I believe that those penalties will not be adequate to achieve the kind of gain that we want to see. In the explanatory note to the bill, Mr. Speaker, government says the analysis indicates that conservatively an average of 3.4 fatalities and 64 injuries per year could be saved, and that the policy would have a positive net present value of $200 million over 10 years, etc., etc. The question for me, Mr. Speaker, is I don't see how those numbers were derived, because actually with the lower level of penalties, the disincentives, the shapers of behaviour that we use currently above 80 milligrams will not be the ones that we use. And so those numbers may in fact be an overly optimistic estimate based, Mr. Speaker, on the lower level of disincentive that the government is intending with this bill. The additional points I'm going to be looking for in the submissions, Mr. Speaker, first of all, is 50 milligrams low enough? You know, why ought we to have any permitted level of blood alcohol? And certainly other countries, Sweden and Norway, for example, have effectively a zero limit. And they have that because they recognise, and it's set out in Safer Journeys, Mr. Speaker, that actually at any level of alcohol consumption, judgment and skill are impaired. People become worse drivers, and that means that they are more likely to cause crashes with all of the consequences of fatality and injury to themselves and to others. So why any limit at all? Is 50 milligrams low enough? And the other point, Mr. Speaker, is another change that hasn't been discussed so far in this debate, which is that the government is intending that someone who is found to have more than 50 milligrams at less than 80 milligrams will not be able to seek a blood test. So they will get their infringement notice on the basis of the breath test alone. And I'm going to be very interested, Mr. Speaker, to see what submitters have to say to the Select Committee about that quite significant change. So with those reservations, Mr. Speaker, I again state that the Green Party will support this bill at first reading. Thank you.
Mike Sabin.
Thank you.